Probate documents are one of the best primary source documents out there, but they're also one of the most complicated, partly because of the dizzying array of different document types, such as wills, bonds, letters of administration, letters testamentary and other administrativa, inventories, probate proceedings, settlement, and guardianship. I'm Mike O'Neill, and I'm going to give you an overview of different probate documents in 5 minutes if I can do it. If you want to dig deeper, I recommend spending some time at Bob's genealogy filing cabinet at genfiles.com. In this video, I'm going to focus on testate proceedings, and that's where a person made out a will. I'll cover guardianship and intestacy, where there's no will, separately. Now, testate probate proceedings are the most straightforward. At a minimum, you will have at least a last will and testament, which documents how a decedent wants his or her property to be distributed. Wills are fairly boilerplate. You'll see similar language in all of them, and there are a couple conventions which are incredibly helpful for genealogy. First, listing children in birth order. It's not used all the time, but when you have no other indicators of age, assume the kids are listed by age. It can be a really useful way to narrow down your search. And second is the clarifying text listing sons-in-law that often appears in wills. For example, Caroline, who is intermarried with Henry Roth. When looking at testate probate proceedings, you may also encounter letters testamentary, bonds, and an inventory. Now, these are just administrativa, and the only genealogical value is that the people named tend to be family, friends, associate, and neighbors of the deceased. Sometimes you'll get a relationship specified for maybe a single person in a document, but that's really about it. Now, to go into detail for all of those, letters testamentary state that a given individual is the estate's executor and can transact on behalf of the estate until it is settled. Getting this letter isn't always necessary. In some locales, if an executor is named in a will, she has the legal authority to act on behalf of the state. She doesn't even need to prove the will in court, at least to get started. You may also see references to bonds. Now, these are a financial guarantee that the executor won't embezzle from the estate, for example. If a court later found the executor guilty of financial malfeasance, the executor would be held financially liable for an amount that could be higher than the estimated value of the estate, and that depends on the extent of the malfeasance. Inventories are the output of an estate sale and can come in two parts: an estimate of the value of personal items and the actual bill of sale of those items. These can be interesting in learning about the decedent's possessions and how they lived. The bill of sale might include family members making purchases, but they probably won't be identified as such. Still, that can be a lead for figuring out who a decedent's daughters married. Sometimes the execution of a will can go sideways, and you'll find a record of this in probate proceedings. Now, probate proceedings might appear in the same court where a will was proved, but it could appear in a completely different court. For example, if the decedent's spouse was pregnant when the decedent died, state law might render the will invalid. At that point, it would become an intestate proceeding. Or the terms of the will might be impossible to meet, and the decedent's family may have to sue the executor, who was probably a sibling or a spouse. Even if the executor was in agreement, our adversarial court system means there must be an appellant and a respondent. Now, I found a case where a wife had to sue her executor husband over the disposition of her father's estate. The executor, of course, testified in court that he was in complete agreement with his wife, but she still had to sue him. The actual court handling probate proceedings may vary state to state, and depending on the type of proceeding, the courts may vary within the state. That can make it really difficult to find. I'll cover hints for this in another video. The final document type you may encounter is an estate settlement. In my experience, this is the rarest type of document to find, and it's typically part of probate proceedings when something gets complicated. But it is worth calling out because of its potential high genealogical value. If the will explicitly lists out all the family relationships, the final settlement won't matter much. If the decedent didn't map out familial relationships, perhaps by saying, and I quote, "I leave my entire estate to my children, share and share alike," a settlement, that's going to be gold, because share and share alike means that each child gets an equal share of the estate. So even if relationships aren't named, you will know that all the people receiving the same amount of money are siblings. Final settlements can also help when the recipient of one of the decedent's bequests passed away. The settlement will list out the bequest and then name all the people who received it. That will be the heirs of the recipient. I actually had a case where this was the only way to prove lineage, as there were no baptismal records, and both parents, Jacob Slow and Elizabeth Morey Slow, died without leaving any trace in probate records on their own. But Elizabeth's father's final estate settlement named her and listed all of their children together because Elizabeth had already passed away. More important, the sum of the share of the estate given to her children equaled that given to Elizabeth's siblings, proving that they were grandchildren of Elizabeth's father. Thanks for watching my video. If you've got any suggestions or feedback, please leave them in the comments.